The first matter to come before the court this morning is State of Ohio versus John Dellagnese III. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you, the appellant, wish to reserve any time, if you want to let me know when you get started, I'm keeping the clock this morning to keep you apprised of the passage of time. We've read the briefs and we're ready to see the matter.
Thank you, Your Honor. Please, court and prosecutor. Good morning, judges. I don't think I'll need to reserve any time, Judge, so thank you. Your Honor, I think there's three issues in this case. The first have to do with the tip itself in this case. Is the tip reliable? And secondly, does the tip cause a reasonable police officer in the similar circumstances to believe that there's criminal activity afoot? And thirdly, what is the impact of the police officer's observations, particularly in this case, after he comes upon the scene and sees, in this case, a car, what is the impact of his observations upon this legality of the stop? What I'd like to do is just talk briefly about Mommy versus Wisner, which is our state Supreme Court's decision in 1999. Talk about two or three cases from this court regarding these issues, and then finally end up with Navarrete, which is Navarrete versus California, with the United States Supreme Court decision that I think if I am going to be successful in this case, I'm going to have to go through Navarrete. So, first of all, Mommy versus Wisner was and I'd like to talk specifically about the calls here, the tipster calls. And particularly in light now of Navarrete, which I think does away with the distinctions we used to make about anonymous. You notice Navarrete doesn't even talk about the anonymity of the caller, because in today's market, in a 911 situation, what Navarrete does is that's just one of the criterion for determining the reliability of the call, because now we know that the system is such that we know where somebody's calling from, the address, probably the phone number. So we're not so much concerned about, is this call anonymous? And we had different levels of reliability for each of them, but Navarrete doesn't even speak to that. So in Miami, Mommy versus Wisner, the call was, there's a car weaving all over the road. It gives the make, the color, the license plate number of the car. And that person followed the car, was so concerned about the activity of this car, she followed the car through town to a railroad and kept calling the police as she following. It's now at the corner of such and such, where a railroad crossing. That's when the police come there and they observe this car matching the description she had given in a parking lot. He then goes, and I think in Mommy they found, I think Mommy was a marijuana case, but anyway. So that's what starts it all. Basically what Mommy tells us is where there's an officer making an investigative stop, and he relies solely upon a dispatch. The state must demonstrate at the suppression hearing that the facts precipitating the dispatch justified a reasonable suspicion of criminal activity. There's nothing like, does the call itself create probable cause or a reasonable assumption that there's criminal activity? The question still is, and I think as Navarrete points out to us, and as our state Supreme Court pointed out to us almost 20 years ago, it's a two-part question. Is the tip reliable? And secondly, does it give reasonable suspicion of criminal activity is afoot? I think it's the same thing, and nothing has changed in Navarrete. It's just how we apply it. This court has, and I did. Frankly, I couldn't find any decision of this court that didn't uphold the tipster report. But I found 3 or 4 over the years, and we've cited them in our briefs. Gatanzarit in 2005. There's a guy at the drive-thru. He's drunk. He almost hit the building. He dropped the money out of his window of his car, and then he gives a license plate and the number. In Rapp, which was a 2013 case from this court, there's a green truck. He can't drive within the lanes. He's all over the place. Then in Gaylord, 2005, there's a car out and it gave the direction of the car, I think it was in anyway, wherever it was, a large noisy truck that just keeps driving around in circles, going around in circles very dangerously. Those are the calls that came from, that this court has talked about before, and whether or not they are reliable, number one, and number two, whether or not they give a reasonable suspicion of criminal activity afoot.
So what do we have in this case?
This
We have a person who, I guess it turns out, I don't know whether the officer knew this at the time, but turns out to have been a police dispatcher.
Correct.
Who sees this vehicle driving, from his perspective, recklessly, speeding, going left of center, taking off at
The red
traffic
lights.
light, right.
Correct.
To the extent that he follows it, I guess, from maybe the Wallhaven area up until
Correct.
about
Exactly correct, right by West Point Market.
Right.
He followed all the way up to virtually the mall. I think he said he turned off to have dinner with his wife. He said if the car was speeding, it accelerated at a light, drifted to right almost, and then came to a quick stop at the final destination, which I think probably was out there before the mall at that Gent Road. Quick stop, almost rear-ended the vehicle.
Right. So what, using the language that you quoted from Maumee, that whether the facts precipitating the dispatch point to criminal activity, why don't those facts which precipitated the dispatch point to the likelihood of criminal activity?
I think one of the reasons is the definitions finally in Navarrete. We got some help here. The Supreme Court said, it is a common sense analysis. Certain behaviors are sound indications of drunk driving. For instance, they said crossing over the center line, almost causing a head-on collision, driving all over the road, driving in the median, and a reliable tip that alleges this kind of dangerous behavior generally may justify the traffic policeman in stopping this person for the suspicion of drunk driving. It depends on where you draw the line. It's our contention that when you take in Navarrete, the conduct in Navarrete was, and this is a verbatim, the southbound Highway 1 at mile marker 88, silver Ford 150 pickup truck, 8 David 94925, ran reporting party off roadway. It was last seen approximately 5 minutes ago at 3:47. That's the report in the Navarrete case that was before the U.S. Supreme Court. What I'm saying, and what I'm asking this court to decide, is the report given in this case a speed, accelerated at light, drifted some to another center lane, come to a quick stop at a red light? Is that the same, at the same level? Because not only does tip have to be reliable, and Navarrete confirms it, it must indicate not just reckless behavior, because that can be explained, a kid, a telephone call, a child throwing something in the car, a heart attack. And Navarrete discusses that. But it's not going to, what Navarrete says, this has to be something more than that. This has to be criminal activity.
Well, excuse me, you're suggesting that the repeated violations, this wasn't just one aggressive departure after a red light. This was, I don't know how many times the
I think
same.
twice.
Okay. It seemed to me that it happened frequently. I don't know how many lights it was, but would you deny that the length of a pattern could possibly support
Obviously, I would not.
the charges?
Obviously, I agree.
So where are we to
It
go
depends
at
on
that
where
point?
you have in the spectrum here. Does the fact that he squealed his tires or whatever he did from 2 lights versus 1 light, does the fact that he in this opinion, was driving at a high rate of speed, does that, I don't know, does that amount to a indication to a reasonable officer that this man is drunk? Or could it be?
Well, it could have been other violations.
Could have been.
It doesn't necessarily at that point for the officer to believe that this man is drunk.
I think the overriding thought here is this person is drunk. I think from the 911 call all the way through.
Well, that may be true, but if the actual conduct was sufficiently egregious, drifting and a danger to the rest of the traffic, or I don't know all of that. It might just be the icing on the cake when the officer finally gets up there and smells the alcohol. So I'm not sure that the alcohol is the real issue here. It's what happened between
Absolutely.
First came to the attention of the witness and what happened during that.
It was our position at the hearing that because the officer blocked him, and I was going to get to that next, the officer picks him up at Cleveland Masson Road. He's sitting watching traffic, and he's hearing this 911 call that's on one frequency, but is shared by Fairlawn and Bath and Copley. He hears this call and sees a Land Rover, or whatever kind of car it is. It's a different color that he sees than the, I'm not sure that's important, but he sees a car, he then pulls behind it and follows it for just 30, 40 feet, he says, which there's a McDonald's there. The car then pulls into McDonald's, and it goes into the carryout line, makes an order, he's behind it, makes an order, pays his money, goes through the carryout line, picks up his food, and then pulls into a parking spot. The officer then pulls around and locks him in. It was our position that under Terry, that his freedom of movement is substantially impaired. So you're absolutely correct.
But that's not the issue.
It's part of the issue, only because this court has repeatedly held that in all these cases that I have talked about, has repeatedly held that because the trooper did not witness traffic violations while following, does not lead us to conclude that he lacked reasonable suspicion.
Did that case involve a tip?
That case involved a tip. And what the issue here, and the issue we raised here, and the issue in Navarrete was also that what if the officer, in following the person that he follows up with a tip, doesn't see any illegal driving, any reckless driving, any of that nature? Does that affect it? Navarrete says it shouldn't. Navarrete says unless. Navarrete says, nor did the absence of additional suspicious conduct after the vehicle was first spotted dispel the reasonable suspicion of drunk driving. Extended observation of an allegedly drunk driver might eventually dispel a reasonable suspicion of intoxication. Okay? So they're not ruling that out. What they're saying is it may have an effect. I mean, and what I'm saying, Your Honor, is that this officer, in going through a drunk person is a drunk person. Okay, you don't turn it off like a light switch. I mean, and that's always one thing that I've always argued. You don't drive, you're being reckless and then automatically don't be reckless. It just doesn't work like
So
that.
you're saying because he navigated around McDonald's, he could not have been impaired on the way to McDonald's?
What I'm saying, because he navigated around through all that at McDonald's, what I'm saying is that has an effect upon the reasonable suspicion of a police officer who has not seen any behavior. He's relying solely on the tip, solely on this 911 call. Not that he's required to have any additional observation, but doesn't that weigh into it? And I think this Navarrete says it can weigh into it. And I'm asking the court to consider that this is not just that he's driving down the road. This is he's navigating through, paying money, going through I mean, my wife can hardly do it sober. I mean, I got marks on my car from it. I mean, so I'm just saying that could very well affect a reasonable suspicion of intoxication. So those, I think, are the issues that I wanted to bring to the court's attention.
Could you speak speak just briefly to this question that you have raised in your brief about the fact that the caller didn't identify himself?
You know,
What's the import of that? Are you
I think I'm giving
backing
up
away
on
from
that. I think frankly, Judge, it didn't come out the way it should have. It could have come out a lot better than it did. I mean, and I guess I got hung up on the fact that I knew what the evidence was, and it wasn't the evidence. So I guess what I'm saying, and given Navarrete, when it says that that's merely a indicia of reliability, one of the things we look at to see if something's reliable or not. The fact that this person called 911, it was a 911 call. The fact that obviously they knew how to get a hold of the person was subpoenaed to the hearing, and the person actually testified that somebody called him back the next day. I think those are all circumstantial evidence that probably even under the old standard, that it was a 911 call, that it was a known citizen informant. So I'd give up on that.
Thank you, Counsel. Thank you. I may please the court, Attorney Whitney. I agree with Mr. Whitney in a lot of respects. I do think that we have 3 issues here before the court. The first one being...
Excuse me, you should probably start by introducing.
Oh, I apologize. My name is Marissa Pappas. I'm an assistant city prosecutor for the city of Akron. We'll be representing the appellee in today's matter. Thank you. I'm sorry. But I do agree that we have 3 issues, one being the 911 call, the 911 caller, one being the observation, the second one being the observations of the arresting officer, and the third being the tip itself. I know that Attorney Whitney just basically conceded that perhaps this was an anonymous caller, but just to reiterate for the court that even though there was no direct testimony from the 911 caller at the suppression hearing, he did testify, that he did give his name and number. He did testify that he was told that he would be contacted, and he was in fact contacted the next day by the police officer, and that the officer further, he testified at the suppression hearing that he instructed the dispatcher to make sure that we had his contact information, and the dispatcher did in fact do that. Similarly to what Attorney Whitney said, he did appear at the suppression hearing. He was cooperative in the prosecution. He was a former dispatcher and 911 operator, so he was very familiar with the process. With regard to the arresting officer's observations, I think it's important to note that there are a couple cases that address this very issue. I know the appellant in his brief argues that the officer observed no erratic driving, and in fact he argues that he observed some good driving at the drive-thru. But we all know that Terry says that we can make a brief investigatory stop based on reasonable suspicion of specific and articulable facts that criminal activity is afoot. The Supreme Court has long held that the idea that reasonable suspicion can only be established based on officer observation is just not the case. Information supplied by other people has long been held to be acceptable. Similarly, I'd like to point out that an officer with reasonable suspicion based on a tip is not obligated to surveil the vehicle long enough to dispel that reasonable suspicion. In the new case that we've talked a lot about is Navarrete. The court says that reasonable suspicion could be dispelled by officer observation, and I know Attorney Whitney just addressed that case with the court by saying that, yes, enough observation by the police officer could dispel the reasonable suspicion supplied by a tipster. However, in the very next breath, the court goes on to say, but in this case, the 5 minutes that the officer followed the police officer, and I'm going to quote it, the 5 minutes of good driving hardly sufficed in that regard, meaning that 5 minutes of following a car after a tip in Navarrete would hardly suffice in that regard, meaning that 5 minutes in that case wasn't enough. In this case, we have an officer who observed the defendant driving on the open road for 30 to 40 feet before he pulled into McDonald's. And once in McDonald's, we had very limited driving. So based on what Navarrete says, it says, yes, eventually maybe good driving observed by the police officer could dispel reasonable suspicion, but the 5 minutes they had in Navarrete, they said, was not nearly enough. And in this case, we have even less than that. Now, I know the dissent in Navarrete strongly disagreed with that. However, if we take into account the facts that we have in our case at hand today, all the officer observed was 30 to 40 feet of driving on West Market Street before he pulled into
a drive-through line, which, I mean, we've all been through a drive-through line, you basically pull up and you stop, and you pull forward and you stop. So it's very, very minimal amount of driving. So the one sentence that I think that the appellant wants to focus on in Navarrete, where it says eventually officer observation could dispel reasonable suspicion, I just don't think that the facts that we have in this case rise to that level. Lastly, I'd like to talk about the tip itself. The appellant has already discussed Mommy versus Wisner, which is an Ohio Supreme Court case that directly addresses this issue. It says a telephone tip by itself can establish reasonable suspicion to justify a stop, where this tip has sufficient indicia of reliability. We use a totality of the circumstances approach in that case. There's 3 factors that the court has outlined, and they have been used again and again. That's the veracity of the tip, the reliability of the tipster, and the basis of that tipster's knowledge. Now, in our case at hand, I think some of the facts are especially important to evaluating those 3 factors. The tipster, when he testified, I think it was Kyle Barron, the 911 caller, when he testified at the suppression hearing, he stated that a champagne color Range Rover flew by him, that he encountered this guy at several traffic lights, he accelerated very rapidly, he gunned his engine so loudly that it shook the windows on Barron's car and caused the Range Rover to drift right over the center line. He said that he narrowly avoided an accident. This 911 caller was a former, like I said, former dispatcher, former 911 operator, and he knew to call 911. He stated that the Range Rover was unable to maintain its lane, almost sideswiped a vehicle, nearly rear-ended a vehicle, and appeared to be intoxicated. Furthermore, this caller was able to give the dispatcher the location, direction of travel, color, make, model, and the license plate of this vehicle. And I think that goes to exactly what Attorney Whitney was discussing, in that when there is a tip at the suppression hearing, state is required to show that the information provided by the tip rises to a level of reasonable suspicion. And here, this is not a minor traffic violation that was being reported. It was several egregious violations over an extended period of time. We know that the tipster first encountered the defendant somewhere near Wallhaven, and they eventually parted ways at Summit Mall. That's a good stretch of roadway there. That there's several traffic lights, it's quite a distance, and the police officer encountered the car matching the description just 1 or 2 traffic lights later near the intersection of West Market Street and Cleveland Maslin, near the McDonald's, where he was eventually stopped. So
Do
going
we know, counsel, whether the tipster, or where the tipster was when he, along that stretch, when he called 911?
I do not know that information. It's not clear from the record. But I mean, based on what I do know, I can assume it's somewhere between the Wallhaven and Summit Mall. He did call and tell the dispatcher that he observed a few things at several lights, so I would assume, and I would submit to the court, that it was closer to Summit Mall. The call was placed closer to Summit Mall than to Wallhaven, simply because of what he reported in his 911 call.
Do we have the 911 call?
No, this was not a case that I presented at suppression, but from what I can understand and what I can gather is that this was a Farallon 911 call, where the call was placed. It was a Farallon call. Montrose, Bath, and Farallon, Copley, and Bath have an agreement to all kind of patrol and observe the dispatch for Montrose, because it kind of overlaps all those jurisdictions. So it was a Bath police officer, but a Farallon dispatcher. And I think that's where the confusion got, but there was never a 911 call admitted as evidence at the suppression hearing. I also wanted to briefly discuss the Catanzari case, and I'm sure I'm saying that name incorrectly, and I apologize. But that exactly, I think, is right on point. This is a case where a drunk driver went to Taco Bell. The tipster in that case was a Taco Bell drive-thru worker. She observed no driving other than pulling up to the drive-thru window. And she called the police based on the interaction she had with the driver at the window. And in that case, this court held that that was enough for reasonable suspicion of drunk driving. It again used the same 3 factors: the veracity of the tip, the reliability of the tip, and the basis of the tipster's knowledge. I would lastly just like to leave the court with the new Supreme Court, U.S. Supreme Court, the Navarrete case. In the state's opinion, it is right on point. In that case, I think it's important to know, because you obviously know the facts already from Attorney Whitney, but I would just like to leave the court with the fact that in that case, it was merely a footnote that both parties agreed that this was an anonymous tipster, and it didn't even factor into their evaluation. They were, at least it was the first time that I've read, where they basically stated the fact that the tipster used the 911 system lended credibility to the call, because nowadays everybody knows your call can be traced and it's being recorded. And that the fact that a false tipster would think twice before using the 911 system. Now, I know the dissent pretty adamantly disagreed with that. However, because they basically stated that's only an addition of reliability if the caller knows he's being recorded. And in this case, I would again submit to the panel that this was a former 911 operator and dispatcher. He knew he was being recorded. So while there was not direct testimony at the suppression hearing that yes, he gave his name, number, address, contact information, he was contacted later, and he was a former dispatcher, so he knew he was being recorded, and he did come to the suppression hearing. That case also, the Navarrete case briefly touches on the fact that there needs to be a basis of reasonable suspicion from the tip in the eyes of an objectively reasonable police officer. And I won't repeat all the facts in this case, but there were a ton of allegations that this 911 caller made. The speed, the almost causing accidents, almost sideswiping vehicles, revving the engine so loudly that it shook car windows. This was not a minor traffic accident. So in the eyes of a objectively reasonable police officer, there was reasonable suspicion. Based on that, I would ask that this panel affirm the decision of the trial court. That's all that I wanted to address with the panel, but I would be open for any questions if there are any.
Seeing none, thank you. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. We may adjourn briefly until 10:30.
Thank you.